This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky.
There is a real substantive issue here.
I'm not going to excuse your conduct because you had a crummy childhood, because lots of people did, and they didn't murder anyone.
If the legislature says that there's a public purpose, then by golly, there's a public purpose.
If there's a way to Governor Parsons' heart, I haven't seen a lawyer find it yet. Welcome to St. Louis on the Air. I'm Sarah Fensky. A St. Louis police officer crashed his SUV into local gay bar Bar PM, and then another officer swiftly arrests the bar's co-owner. Now the officer who made that arrest is facing 2 lawsuits. Do they have a good chance of success? The state of Missouri has again blocked the Biden administration's aim of canceling student loan debt. Will the state succeed in its quest a second time? And a group of gadflies is suing the city over its Universal Basic Income pilot program. Is that program unconstitutional? These are big questions, and they deserve good lawyers. So fortunately, we have 3 in the studio with us today. First up is Susan McGraw. She's a professor at the St. Louis University School of Law and director of its Criminal Defense Legal Clinic. Susan, welcome back.
Thank you, Sarah.
And we're also joined today by Dave Rowland. He's the director of litigation at the Freedom Center of Missouri. Dave, welcome back.
Thank you, Sarah.
And back with us today is also Arindam Kaur. He's a shareholder at Polsinelli. He focuses on antitrust compliance, counseling, and government investigations. He also provides outside general counsel services to higher education institutions and emerging entities. He regularly handles pro bono immigration matters. Arindam, welcome.
Thank you.
So big news from the U.S. Supreme Court this morning. The nation's highest court rejected Missouri's argument in Murphy versus Missouri. The state had alleged that government officials pressured and coerced social media companies into censoring speech that they didn't like, specifically speech about the COVID-19 pandemic. Now, this ruling came down to standing. Justice Amy Coney Barrett wrote that the states that brought this suit cannot, quote, manufacture standing merely by inflicting harm on themselves based on their fears of hypothetical future harm that is certainly not impending. So big question of standing here. Susan, what does that mean in layman's terms? And is this possible that the attorneys general of Louisiana and Missouri were simply the wrong person to bring this lawsuit?
So, Sarah, standing is a way that the courts prevent multitudes and multitudes of filings. It's a way of kind of limiting who gets to file a lawsuit. And there's 3 requirements for that. There has to be an injury. So the person filing the lawsuit has to have been injured or has a concrete injury or risk of one. There's got to be causation, right? So the injury that I'm alleging in my lawsuit has to be traceable to the conduct. Mm-hmm. And third is redressability. You've got to allege an injury that the court can help you with. So this prevents people who are not associated with a bad product or a bad ruling from just filing whenever they want. We want to know a person has standing or a real interest in the case that they file.
So is that former Missouri Attorney General Eric Schmidt in this case?
I think the answer was no, but I'll let Dave get more into that.
Yeah, the answer in this case was no. So the problem that the plaintiffs had here is, although the court did not seem to foreclose that perhaps the Biden administration did some things that could have been constitutionally suspect, there was not a direct causal link between what the record shows and an injury to any of the plaintiffs in this case. And so that was really kind of the fatal flaw here. And so I think that had a better set of plaintiffs or the correct set of plaintiffs brought the same claims, maybe you get a different result. But you basically, you dance with the girl who brung you. And in this situation, they just couldn't demonstrate the harms that were necessary to get a ruling on the merits in this case. So one thing I would like to add is This case was heard, the oral arguments in this case were heard the very same day that there was a case out of New York dealing with the National Rifle Association that raised very, very similar issues. And so although for those of us that are big free speech advocates, it would have been nice to have gotten a ruling on the merits in this case, quite frankly, the Supreme Court probably did all the heavy lifting for the First Amendment that it likely would have done if the right plaintiffs had brought this case in the Volo case, which is where the court said you absolutely cannot coerce private actors in terms of who they associate with or how they speak to other people by threatening them with regulation. And so I think that walking away from the Supreme Court term, we got the result in Volo that probably covers most of the bases that would have been covered in this case had there been standing for the plaintiffs.
So a loss for Missouri, but still a victory possibly here for the First Amendment.
I think so.
Now, Justice Alito disagrees with you. His dissent, he says, quote, what the officials did in this case was more subtle than the ham-handed censorship in Volo, but it was no less coercive. And because of the perpetrators' high positions, it was even more dangerous. It was blatantly unconstitutional. He says the takeaway should be if a coercive campaign is carried out with enough sophistication, it may get by. Interesting take from Judge Alito. Very much a dissent here. Arindam, I want to ask you about something I noticed on St. Louis Twitter earlier this morning. The appellate lawyer Chuck Hatfield wrote, quote, lack of standing is the worst. It's like they say, sit down, counselor, which one never wants to hear from a judge. Do you think this suggests that the justices are taking kind of a dim view of these activist attorneys general who are trying to bring all sorts of, sort of red meat to their bases and taking it to the Supreme Court?
From my perspective, unfortunately, no. The justices decide on the narrowest way possible to adjudicate those cases, and you didn't have standing here. So while one, at least from my perspective, would love to see that, glean out of that, I don't think that's the case.
Dave?
So I think there's an interesting parallel for your question with the student loan cases that the Supreme Court heard and decided last year, because standing was a hot issue in that one as well. Ultimately, the majority of the court found that Missouri had standing through MOHELA, the loan administration agency here in the state. But Justice Kagan had I thought, really compelling dissent where she says, look, there's no indication that MOHELA wants to be part of this case at all.
Yeah.
Like, where's MOHELA?
And I think MOHELA has made
this is the Missouri Attorney General
argument.
Yeah, exactly.
MOHELA has said, we did not ask for this case to be brought. We don't support this case.
Right. And so I think to the extent that we might like to hope that the Supreme Court is discouraging these enthusiastic, shall we say, attorneys general from bringing cases like this, I think it depends on the case. It depends on the case whether or not they're going to indulge the enthusiasm of some of these attorneys general.
Interesting. I do want to talk about that Missouri student loan case because there's another one that has flared right back up. But before we do that, I do want to mention one very small note in this Murphy versus Missouri that caught my eye. Jim Hoft of St. Louis-based blog Gateway Pundit was a plaintiff in this case, helped bring this case, claimed that he had standing because he published blog posts that Facebook then suppressed. They didn't want people to see his theories about COVID-19. Well, Justice Barrett mentioned him in her opinion in this case. She wrote that the allegedly censored post written by him was actually written by his brother. Arindam, how do judges deal with that kind of sloppiness? Is it normal that you'd see them kind of slap someone down and say, hey, that's your brother. You're not allowed to bring this case?
I've seen everything, right? I've seen judges who have been very straight and narrow, and judges, whether it's someone, like Easterbrook or someone, just go to town on these things.
Yeah.
And the opportunity was here. Standing was the, decision that was here. And so I think they doubled down on that there.
Yeah, I guess they should have had the brother sue.
Yeah.
Could have been a different outcome.
Yeah.
So, okay, the state of Missouri, they previously stopped the Biden administration's plan to forgive some student loans. Well, in this last month, a case they brought against his more recent attempt to forgive student loans ended up before St. Louis-based federal judge John Ross. He wrote, yeah, I got to block part of this here. He noted that the arguments are substantially similar to Missouri's previous case against student loan forgiveness. Dave, does that mean he's bound by the Supreme Court's ruling in that previous case?
I think it does. Really, the question here is, did Congress give the authority that the Biden administration has been claiming? And the answer in last year's student loan case was no, Congress has not given this authority. And if a federal executive intends to wield this kind of authority, then Congress has to act. Congress has not acted in the last year. And so I think that to a very significant extent, the court's hands are going to be tied in how they deal with this going forward.
Arindam?
Yeah, no, I would agree with Dave. And to the earlier point of bringing similar types of claims over and over here, this is one where there is a real substantive issue here of the idea of what's called the major questions doctrine, rulemaking on this one, and this is still pending with the Supreme Court, this idea of the Chevron doctrine, which is giving certain deference to agencies on rulemaking and things like that. But these arguments, while they have been successful on this loan case, at least in previously, this is a court that really does want to re-examine the authority of agencies, and these are the same arguments that are going to come up. I deal with the Federal Trade Commission a lot. So the whole national ban on non-competes, very similar. Did Congress intend the FTC to have this authority under the Federal Trade Commission Act? So you're seeing these similar arguments being applied in agency overreaches, or at least the issue of whether there's an agency overreach.
Should the Biden administration then have seen this coming? I mean, this is, again, a very similar forgiveness to the last time around.
I think, and this is not just me, if you go to Politico and other places, this is absolutely a campaign piece. I think they knew there was going to be issues here, similar to some of the immigration decisions they're making.
I wanted to chip in here. It can be tough when there's an issue that we feel very directly. So I know a lot of people listening probably have had student loans and they like the idea of student loan forgiveness. But I do actually think it's important that the Supreme Court require the branches of government to play their proper roles and to be confined to their proper boundaries. If we are going to be the kind of governmental system with checks and balances that we were designed to be, we need to have Congress being clearer about what authority it's creating, who gets to wield that authority. We do not want the executive branch to just be able to make things up as they go. Remember, that may work well when you've got a president who thinks the way that you do and that views different issues the way that you do. But if you get someone with a different perspective, you don't want them to have that authority. That's why I try and maintain a really principled line that it is important for the Supreme Court to say, look, this is Congress's role, and if Congress doesn't exercise it, that does not give the executive leave to kind of try and make law on its own.
So Biden's program here could be in some trouble. We need to take a quick break. When we come back, we're going to talk about that lawsuit involving the Bar PM case. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. So last month saw big news in a case that we've previously talked about on this show, and that involves the gay bar called Bar PM. A rookie cop crashed his SUV into the bar. When another cop responded to the scene, the cop handcuffed not just the car's driver, he handcuffed not the car's driver, but the bar's owner, and that was within 22 seconds. of arrival on the scene. When the husband of the bar's owner complained, the officer ended up arresting him and allegedly beating him up. Now, the bar owner has now filed a lawsuit against the city and 2 different cops. One of the cops in the car that crashed into the building, and then Ramel Wallace. He's the cop who responded to the scene and swiftly arrested one of the bar's owners. Now, this lawsuit was filed by Javad Kazali, who's a sometime panelist on this show, and Susan McGraw is now working on this case. So, Susan, you are not going to throw down and give us your whole legal strategy here on public radio.
I will not be. I will add that my law colleague, Brendan Roediger, and Jack Waldron were also instrumental in filing this.
Okay, so Javad should not hog all the glory. A lot of lawyers working on this one. And it's going to be interesting to see how this one plays out. Arindam, something that caught my eye on this one is that the bar's owner is not suing the officer who drove the car and plowed it into his building. I think that's something that a lot of laymen would just assume. Oh, yeah, you sue the cop who drove the car into your building. Why aren't we seeing that in this case?
So my understanding on that, there are some statutes as it relates to negligence by a government official driving a motor vehicle, and there's some caps that are involved as it relates to the agency. So I think a combination of trying to get this a straightforward case is one of the reasons, at least from my perspective, why they didn't go after the driver. And again, really, the conduct that is being focused on is the allegations of the assault and the arrest.
Yeah. And I think that arrest was so eye-catching because we're like, wait, they crashed into this bar and then they arrested the guy. But it's what happened in this arrest that's really the focus here. Dave, this officer, Ramel Wallace, he has a history of being sued and allegedly being violent. Will that matter to the courts and potentially to the jury here?
It certainly should. It's a good question as to whether it will or not. So as listeners may be aware, police officers are frequently given multiple layers of immunities that can shield them against accountability for various types of actions. Now, if an officer's actions are truly egregious, then sometimes the courts will break through those immunities and allow a lawsuit to go forward and allow them to be held individually accountable for their actions. But that tends to be the exception rather than the rule. And I think that it highlights the importance of accountability for our police officers. Unfortunately, one of the things that we see consistently and across the board is kind of this blue veil of silence that tries to be drawn across these situations to kind of insulate the individual officers from criticism or legal accountability for their actions while in uniform. And that is affirmatively bad for society. If this officer, assuming for the sake of argument that he did in fact do some of these things that he was accused of in years past, if he had been held accountable at any step of the way, then perhaps he would not have been in a position to treat the owner of Bar PM the way that he did on this particular night. That's why accountability and transparency, I might add, are absolutely crucial when it comes to our law enforcement officers. But too frequently, the accountability and the transparency are lacking.
So the lawyers who've brought these lawsuits, including our friend Susan here today, filed another lawsuit on the same day against this Ramel Wallace. This is some just crazy stuff. This one basically alleges that he challenged a detainee who was incarcerated at the Justice Center to fight him. And then he threw the first punch against this detainee. He knocked the detainee to the ground, allegedly manhandled him. There's another incident report quoted in this suit that his neighbor filed a misconduct report accusing the officer of grabbing her neck, pushing her against the trunk of a car, placing a gun against her stomach. Here's a quote from the lawsuit. Quote, "With defendant Wallace's history of allegations of misconduct, it is incomprehensible that he is still allowed to be an officer." Arindam, does that help build that case, not just against this individual officer, but against the city of St. Louis?
I mean, the allegations are certainly eye-opening. From a court's perspective, they have to look at these prior acts and how prejudicial they are to the defendant, because he is being sued for the the conduct, the most present conduct. And so this pattern or history, that's the balancing act that the court's going to have to figure out. Is it does it merit going into a jury, or is it too prejudicial and not relevant enough to the acts that are being prosecuted in the lawsuit?
And here we are talking about this on the radio today. Is that potentially prejudicial to a jury? Is this a jury they're going to have to sequester them, OJ style, and not let them hear what the St. Louis media is saying about this guy?
I hope for the jury pool that's not the case, but we shall see.
It might depend on which judge you get in front of, because as you may recall, there was a gag order put on a reporter related to a criminal case that recently was handled by a St. Louis jury, where the judge prohibited the reporter from publishing a story based on information she had gathered about the case. Now, I happen to think that the gag order was blatantly unconstitutional, but Missouri courts refused to intervene and lift the gag order. And so it sure could be an issue.
I'm excited to say we have no prior restraint here on this radio program. No judge has told me that I'm not allowed to talk about these facts, so I'm going to keep talking. Let's talk about another case here. In this one, Missouri put another man to death. This happened in this past month. David Hosier was killed by lethal injection for causing the deaths of a Jefferson City couple. He had sought clemency from Missouri Governor Mike Parson. But the Associated Press has reported that Hosier was no fan of his own attorney's clemency brief. He felt they focused on the wrong things. They were focused on the trauma he'd faced over his father's death when he was a teen. He thought they should have been focused on the lack of evidence in his own capital case. Susan, does he have a fair gripe? Should the lawyers have taken his direction on, this is his last chance to plea for his life? Should he be in the driver's seat for that?
Well, I think the answer is no, except in very limited circumstances. So I think people probably believe that when you have a criminal case against you, you get to make all the decisions about the case. And that's really not correct. And the reason it's not correct is because there are decisions that only a lawyer who's been to law school, who's practiced, can make. So what we like to say is that criminal defendants' right to decide if they want to testify is only theirs. If they want to plead guilty, that's only theirs. If they want a jury, that's only theirs. But pretty much every other decision is up to the lawyer. And the reason is because, especially in a case like this, you need the experts in the law and the courts to be handling the decisions. I will note that he was asking for clemency, and clemency is mercy. And his lawyers obviously thought that presenting a history of the really terrible trauma he suffered was going to appeal to the governor's heart more than another argument about the sufficiency of the evidence.
And unfortunately, Governor Parson did not have that sort of emotional response they may have been hoping for. I'm not aware of him having that response in any of these cases, which is interesting to me because we have seen him show some mercy to people who've been charged with lower level crimes. I think he has a better track record on that than many people would want to admit. But on these death penalty cases, if there's a way to Governor Parson's heart, I haven't seen a lawyer find it yet. Any thoughts on that?
Yeah, I think that's absolutely correct. And it would take me hours to tell you the type of trauma that people accused in death penalty cases has suffered. 201, very terrible childhood, sexual abuse, physical abuse, things that would really curl people's hair if they had realized how these folks had lived. But I think, at some point our nation said, this is all this abuse excuse, right? I'm not going to excuse your conduct because you had a crummy childhood, because lots of people did, and they didn't murder anyone. So that has progressively been a harder way to get relief for your client.
Arindam?
Yeah, no, I was just going to add to that original point of, how much do you have to listen to your client, right? So, and I think she's absolutely right. There are major decisions are clearly within the client's purview in terms of what you want to do, but the day-to-day things are, that's why you hire a lawyer. And putting this case aside, I think the other point to raise is if you are a client and you have a lawyer that's just not listening to you or not doing what you'd like to have done, that's your purview to say, hey, maybe I need a different lawyer. Now, again, this is a very unique circumstance,
Sure.
but just practically for listeners, you have that right to choose different counsel if there's a misalignment on what you want to do.
Do you have that right if you're represented by a public defender and you don't
Yeah,
have the funds
that's
to go hire a
that's
different
the
lawyer?
distinction, yeah.
Right. So that's the problem.
Yeah.
People with funds to hire private attorneys have much more say because they can say to the lawyer, look, I'm not giving you the rest of your money if you don't fall in line with what I want. Some lawyers will say, well, then you're going to need to go. And some lawyers will change their minds and do what the client wants them to do. I have rarely seen a defense-led, like defendant-led defense be successful because some things just don't fly in the courtroom, right? You need a third objective party to kind of parse out what the best approach is.
I mean, isn't that just what a lawyer's going to say? I'm joking.
Trust us, we're professionals.
Right.
I can't even imagine trying to run
I stayed at a
points.
Holiday Inn Express last night, so that's why I'm an expert now.
Yeah, exactly. So, well, look, I mean, there's another death penalty case that's also in the news this month. This involves Marcellus Williams. He was convicted of killing former Post-Dispatch reporter Trisha Gale in 1998. He has always insisted he didn't do it. Governor Eric Greitens convened a board of inquiry in his case, saved him from the death penalty at the very last minute. Now, that board of inquiry never issued findings. Despite that, the Missouri Supreme Court has now given Governor Parson the go-ahead to go ahead and execute Williams. That board of inquiry lawsuit is something that we had previously talked about on this show, did not have the desired outcome that advocates for Marcellus Williams were hoping for here. And there's another wrinkle in this case. St. Louis County Prosecutor Wesley Bell is seeking to overturn Marcellus Williams' conviction. He says there's a plausible alternative suspect. Dave, I'm actually somewhat floored that Wesley Bell's lawsuit here doesn't just automatically stop talk of execution until it can wend its way through the courts.
I would love it if that's what the statute requires, but the statute does not require the halting of death penalty proceedings while the courts sort out this kind of a motion. Now, one of the things that former Missouri Supreme Court Judge Wolf pointed out is that the Supreme Court has set the execution date several months out from now, and it may be that they are subtly sending a message that they would like to see the courts deal with Wesley Bell's motion before the execution goes forward. In other words, they may not want to see this man executed before the courts have been able to sort out whether or not his claim of innocence is legitimate. I would certainly hope that there would be a definitive ruling on his claim of innocence before irreversible actions are taken here.
Boy, that's the understatement.
Yeah, no
Irreversible
kidding.
actions. Yes, Susan.
So I'll add, it wasn't enough that Wesley Bell agreed that it should be set aside, because at some point, the authority over that case transferred to the Office of the Attorney General. Once the trial work is done, the Attorney General handles the appeals, and they have opposed this. So I don't want the listeners to think that only Wesley has control over this. They've brought in the Attorney Generals, and as pro-life as they have determined themselves to be, they are full in favor of these death penalty warrants.
Okay, so they do want Marcellus Williams to go ahead and get executed while this question is still pending.
They do.
It seems like, we laymen are always hearing about a restraining order went into effect and immediately stopped action. Is there any chance that someone could go for one of these restraining orders and restrain the court from this execution while this is going on? I don't see anyone saying that I have just located the get out of jail free card here. No, it's not that simple.
It's a nice idea, Sarah, but the case is properly before the United States Supreme Court on a writ, which is the next prescribed step. I don't think action to restrain the court from executing someone is going to be what we would refer to as cognizable. I don't think that there's any remedy there. So all our hopes are pinned on the habeas.
We're talking today to our legal roundtable. That is Susan McGraw. We're also joined by Dave Rowland and Arindam Kaur. We do need to take a quick break here. When we come back, we're going to talk about a lawsuit that was filed against the city's Universal Basic Income Pilot Program. There's some really interesting legal questions on that one, so stay tuned. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. So a lawsuit against the city was filed by our sometime panelist Beavis Schock and his group of gadflies. They call themselves the Holy Joe Society. Beavis certainly has a way with words. I'll give him that. They've sued trying to block the city's Universal Basic Income Pilot Program. This program is designed to give $500 a month in public funds to lower income families chosen by a lottery. And in addition to being below certain income levels, they have to have children in the St. Louis public schools. So Beavis and his crew are trying to say that's unconstitutional. And they're saying that because there's a clause in the Missouri Constitution that says you can't give public funds to someone for a private benefit. Arindam, is that a problem for the city?
Yes. It's a provision which, on its face makes sense, right? You don't want the government to give funds to an individual. It is, prevents the corruption and other issues. So, they're utilizing it as it relates to this UBI issue, and I think it is going to be a challenge for the city to overcome it. And again, this is not a remarkable provision in the Missouri Constitution. There are other states that have very similar provisions, and there's also states that are enacting similar laws to prevent this very UBI issue. So, there is, again, that mix of political and legal, but I do think this is going to be a challenge for them.
So Alderwoman Kara Spencer reminded me that she brought a lawsuit maybe like 7 or 8 years ago trying to block funding being given to the St. Louis Blues to upgrade Enterprise Center. And that ended up being settled before it could become a big test case that would prove the point here. Dave, what has the Missouri Supreme Court said about these kind of allegations that are being made in Beavis's lawsuit? Do they agree that this particular provision is meant to stop things like giving citizens $500 a month?
Well, so let me preface by saying that there's frequently a disconnect between what the Constitution actually says and how courts tend to interpret it. So the provision that we're talking about does specifically say that cities, counties, municipalities cannot grant public money to any corporation, association, or individual, okay? Unless the Constitution creates a specific exception to this rule. What the courts have said, though, is that you can, in fact, give public money to individuals or corporations as long as there is a discernible public purpose in doing so. And the way that courts have tended to apply this is they have said, well, if the legislature says that there's a public purpose, then by golly, there's a public purpose. Now, the problem with that is it completely defangs this constitutional restriction on governmental authority.
Yeah.
In other words, what use is a restriction if the government says, I have the right to do this,
yeah,
right? And the courts just say, oh, well, they said they have a right to do this, right? So I actually think that in principle, this lawsuit should be successful. However, in practice, it's going to be a harder sell because for decades, Missouri's courts have basically said, as long as there is a conceivable public purpose here, we're just going to defer to the government's determination. So I got a call from somebody the other day when we were talking about perhaps providing some public incentives for the Cardinals when it comes to their stadium situation. And they said, well, is this something that we could file a lawsuit about? And I said, well, you could file the lawsuit, I'm not certain that it would be a successful lawsuit because of the way courts have interpreted this. And so it may be that the courts take this case as an opportunity to do something a little bit different. I pointed out to my co-panelists just Tuesday, the Missouri Supreme Court decided a case on this same provision, striking down a statute that created lake taxing districts down around the Lake of the Ozarks. And they said that effectively the organizations that were responsible for disposing of the tax money that was being generated were purely private, and therefore it violated this constitutional prohibition on providing tax money to private organizations. But in that case, I didn't see anyone raise the idea of it being for a public purpose. And so that wasn't addressed in the decision. Maybe if someone had said, oh, wait, but we have a public purpose, that case would have come out differently. But it's at least theoretically possible that what this actually indicates is that the Supreme Court's ready to take a different approach on these cases, which I think would be wise, but I don't know for any certainty that that's actually the direction they're heading here.
Susan?
Yeah, Sarah, I'm a lawyer for poor people. Those have always been my clients. And when I looked at the board of directors for this Holy Joe Society, it's some high-power lawyers. It's people who have made a very nice living off of being lawyers. And I'm befuddled why this would be their first foray into the legal scene. And I would suggest that if they were interested in continuing to practice pro bono, that they consider contacting one of the agencies in St. Louis that provides pro bono representation to poor people.
Susan, I certainly am not going to argue with that suggestion. I do want to state, though, they did file a lawsuit before this related to the Charter Commission, and they have actually forced changes. The Board of Aldermen is going to have to sign off on the Charter Commission changes before it goes to the voters. So they're early in their gadfly stages, but not the very first.
Thank you for correcting me, Sarah.
Small corrective. Arindam, I found myself wondering if you can't, if you can make the argument that you can't give people universal basic income, how can you give them, for example, a welfare type payment? Isn't that a very similar sort of thing? I'm surprised that hasn't come under fire.
Well, that is something that I was thinking of as it relates to the TANF program, which is federally funded but administered by the state. Earned income tax credits also going to individuals. But in talking to, again, my hollowed colleagues here, I think there is a provision in the Constitution that makes a specific exception for those state-run type programs as opposed to municipal. So I think that's one of those challenges that you're going to have to deal with. And again, the question is, and this goes back to some of the earlier discussions of, where the power lies to legislate and do this. So if UBI, which certainly has some economic arguments aside from the legal issues, if that's something that needs to be explored, do we need to go to the legislature to address that?
So just to come back in here, the Constitution does create certain exceptions that they will allow these kinds of individualized, for lack of a better term, welfare payments. But the way that it usually couches these is it says that you can provide benefits upon retirement, disability, or death for purposes I'm sorry, I'm looking at the text of the provision right here. Dealing with death benefits, pensions, retirements plans for employees, surviving spouses, and also the Constitution specifically authorizes, I believe, payments for people who are blind or disadvantaged in other specific ways.
Okay.
So there are certain types of payments that are authorized under the Constitutions, just not a broad, generally this person is poor, therefore we're going to give them money. You see what I'm saying?
Yeah. No, that makes sense to me. Dave, I did have another question for you because I know you're a big fan of the First Amendment and the freedom to practice one's religion. Do you think there's a constitutional issue here because they've barred families that have enrolled in parochial schools or private schools instead of the St. Louis public schools?
Arguably, yes. Okay. So there are a couple of different ways that you could come at this. Number one, you could argue that they're being discriminated against because they are engaged in a religious practice, providing religious education for their children. But you could also argue that they are being penalized. In other words, not that they're being discriminated against, but that in effect they are being penalized for choosing to act in a particular religious way. The first approach would be more a constitutional argument. The latter approach, I think, would be under the Missouri Religious Freedom Restoration Act, which specifies that you cannot be disadvantaged for any action that you take that is substantially motivated by a religious belief, even if it's not compelled by your religious tradition. And so if they say, well, I am substantially motivated to send my children to these parochial schools because of my religious belief, and here I am being disadvantaged for that, I think there's actually a pretty decent claim under Missouri's RFRA that the city has violated their rights.
And yet I wonder if the Holy Joe Society would have standing to pursue that.
No, but if there are any parents in that situation, feel free to call the Freedom Center of Missouri.
There you go. A little advertisement for a nonprofit law center there. I want to stay on the topic of religion here. More than a dozen Missouri clergy members filed suit last year to stop the state's total ban on abortion. They said it violated the state law mandating the separation of church and state. Quote, by legislating that life begins at conception, the Missouri legislature dictates a narrowly Christian perspective onto all of Missouri's diverse faith communities. That's a quote from their lawsuit. Now, Judge Jason Sennheiser disagreed with that. Thoughts on his reasoning here, Susan?
You know what, Sarah? I'm unfamiliar with his exact reasoning in this case.
Dave, I know this is one you've studied.
Yeah, this is one of my pet issues. And I think that Judge Sennheiser may have gotten the right outcome, although I don't necessarily agree with the reasoning that he applied here. So I think it's important for people to know that there is a really major issue right now in constitutional law about the role of state constitutions in protecting freedoms where the federal courts have said that the federal constitution does not protect those freedoms. So, for example, the U.S. Supreme Court just recently overruled Roe versus Wade. They no longer recognize the right to an abortion. All over the country, the question is now, well, what about state constitutions? Do state constitutions currently protect a right to an abortion? And if not, should they be amended so that they protect a right to abortion? That's a current issue here in the state. But what we have in this particular situation is Missouri has passed a ban on abortions. And as the plaintiffs note, it does seem to reflect quite clearly a very particular religious understanding about when life is understood to begin. In other words, it reflects a religious belief that life begins at conception. Well, not all religious traditions share this belief. In particular, the religious traditions represented by the faith leaders that are plaintiffs in this case do not share that perspective. And so what they are arguing is that, to narrow it down, I think their strongest argument is that the Missouri Constitution specifies that you cannot give any preference to a creed of religion. And what they're arguing, I think their strongest argument, is that by effectively enshrining into law this religious perspective about when life begins, you are giving preference to a particular creed of religion. Judge Sennheiser didn't get quite that far. They alleged that there would be facts that they could prove that would support their contention. Judge Sennheiser did not let them get to the point of conducting discovery and determining those facts. I know some discovery was conducted, but he ruled on a motion for judgment on the pleadings, which means we're only going on the claims that were made in the pleadings. We're not even going to consider what you may have been finding in discovery. And I think that was premature. I think that the plaintiffs deserved at least an opportunity to show that maybe they could demonstrate that there was a religious motivation behind this statute rather than some secular motivation.
Yeah, I mean, State Rep Nick Schroer, who was one of the sponsors of this bill, he said his Catholic faith compelled him to file this legislation. There maybe would be some evidence there. Arindam.
I know we're low on time. I was just going to add that a similar lawsuit was brought in Indiana that was successful in enjoining the abortion ban there. It was based on the Religious Restoration Freedom Act in that state. which was enacted by then Governor Pence. One thing that would be interesting, and again, maybe for another time, is whether the plaintiffs here relied on the Missouri version of that and whether there was an argument there that might have been more successful, although we won't know because this judge kind of shut all that down.
Could somebody else bring all new litigation, bring it in front of a new judge, different plaintiffs, different arguments?
I would think so.
They certainly could.
Yeah.
Well, if somebody's listening to that, maybe somebody will feel compelled to run with that. We do just have a couple minutes left here, but I want to mention a new Missouri law forces lawyers to make extensive redactions. We've talked about this on this show. It now faces a lawsuit. This case was brought by our regular panelist, Bill Freivogel. The lawsuit was filed by another frequent panelist. That is our own Dave Rowland, who's here today. Dave, what made this such a pressing issue for your clients?
Well, so this redaction statute is really unprecedented in American history. Historically, the judiciary has been the most transparent branch of government, and it has been a window for ordinary citizens into the way that our legal system works. And when you require the redaction of so much information from these cases, including the names and information surrounding witnesses or victims of cases, it makes it much more difficult for journalists or ordinary citizens to understand what are the issues at play, who's bringing these issues, how are they being resolved by the courts. And so our argument is that that violates the First Amendment. It violates various provisions of the Missouri Constitution, including our right to open courts. And it also, the statute that passed these laws or that brought these laws into being did not comply with the procedural requirements that the Missouri Constitution creates for the passage of bills. In other words, this bill started as a very narrow, just a couple page long bill that was focused on judicial administration, and then it ballooned into this 54-page bill that included all these different provisions that had nothing to do with the original idea of the bill. And so it violates the Constitution in a number of different ways. But the bottom line is that this is the first time that we are aware of in the country's history that's required so many redactions without really having a legitimate justification for doing so.
Susan, we have about a minute to go here.
Yeah, I think people should understand that there's always been some redaction going on. Names of domestic violence victims is redacted. Sometimes the names of other violent offenses are redacted. The names of juvenile children in some circumstances could be, especially if they were abuse victims, had been redacted. This just takes it to a whole nother level. Before we had concerns, right, about safety of witnesses, safety of victims, right to privacy of sex assault victims. And this just takes it to a whole nother realm.
And real quickly, is this something that is having a substantial impact on the lawyers that you practice with? They're spending a lot of time on this?
It is, especially I have a colleague who does children's issues, and she spends twice as long probably on drafting things now because she has to be concerned about a lot of different redactions.
Well, I'm sure she's hoping for Dave's success then in the legal arena. We will have to get an update the next time Dave comes in, if not sooner, find out what happens as this wends its way through the court. Susan McGraw of the St. Louis University School of Law Criminal Defense Legal Clinic, I want to thank you so much for joining us today, sharing your expertise.
Thank you, Sarah.
And Dave Rowland, Director of Litigation at the Freedom Center of Missouri, thank you.
Always a pleasure.
And Arindam Kaur, shareholder at Polsinelli, thanks for joining us.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.